Good afternoon to anyone, and we would like to thank you for your interest in the event. We are extremely happy to present the second day of webinars of the subjects Business and Human Rights in Armed Conflicts. Firstly, we, the moderators, shall present ourselves, speak briefly about the URGS IHL Clinic's work, and then present tonight's guest, Dr. Jelena Aparac. We would like to point out that the questions may be submitted on the chat box in YouTube, and following the guest speech, we will move on to questions. With this being said, I will start presenting myself. My name is Jelena Aparac, recently graduated in law from Toledo Prudente University Center, and I act as a legal assistant at the clinic.
And I am Lucas Lichinski, and I am an undergraduate student in International Relations at the Federal University of Rio Grande do Sul, and I act as a student member at the clinic. As per usual, while we wait for the viewers to join our live stream, we would like to give a brief explanation on what is the URGS International Humanitarian Law Clinic. We are Brazil's first IHL clinic, and we serve as a center for legal consultation, learning, and researching on international humanitarian law. We work on many different areas related to the study and dissemination of the IHL, such as the promotion of events and webinars like this one, for disseminating the knowledge of IHL with the general public, the development of research and academic productions on the IHL field, the participation on international moot courts, the attendance in public international law classes as special guests within the Federal University of Rio Grande do Sul, and in the year of 2021, we are hosting our own national monograph competition alongside the ICRC. Today's webinar issue is Business and Human Rights in the Context of Armed Conflicts. It will be focused on Dr. Jelena Aparac's experiences working in the writing of drafts against corporations for international crimes committed in armed conflicts, and also on her experience as a legal consultant for the Médecins Sans Frontières on armed conflict areas, such as South Sudan, the Democratic Republic of Congo, the Central African Republic, and Darfur.
With that being said, we have the honor of having with us Dr. Jelena Aparac. Jelena is the chairperson rapporteur of the United Nations Working Group on the Use of Mercenaries and worked as a legal advisor for Médecins Sans Frontières. She holds a PhD in International Public Law, where she develops a dissertation focused on international criminal liability of corporations for international crimes committed in non-international armed conflicts. She also holds an LLM from the Geneva Academy of International Humanitarian Law and Human Rights. Jelena also worked as an intern into the Appeals Chamber of the International Criminal Tribunals for Rwanda and with the Office for Coordination of Humanitarian Affairs.
We are very honored to receive you today, Dr. Aparac. Thank you for sharing your knowledge on this interesting subject with us. And without further ado, we welcome you and we present you the floor to your presentation.
Thank you so much, Alan and Lucas, and thanks to the International Humanitarian Law Clinic. Congratulations on your being first clinic in Brazil, and I hope you will have successful and fruitful work and collaboration with other academic institutions, also experts and lawyers in the field. I'm also very grateful that you invited me to present a little bit of the work. This research on business and human rights in armed conflict comes as part of the personal experience, but mostly the research as doctoral student at the Paris 10 Nanterre, Paris West Nanterre. It changed several times the names, and it comes as a reaction to what I felt that armed conflict should, when we talk about armed conflict, we should also address the issue of the root causes of armed conflict and the economic aspects of the armed conflict, which very often remain underanalyzed or not necessarily related in a very obvious way to the peace process and peace dialogue and sustainable development after the conflict. So for me, this was one of the reasons why I actually wanted to work on this topic, and it proved very important later on. What do we mean by business and human rights in armed conflict, and what does it actually mean? The traditional armed conflict, the war and the economy has always been linked throughout the history. And today, this is not an exception. We see more and more the reports on the linkage between the natural resources and armed conflict. And some studies have showed that more the conflicts are of non-international armed conflict, or what we popularly say civil wars, more there is a possibility that it will suffer long-standing armed conflict. And of course, one aspect that accompanies these findings is the form of armed conflict. That is to say that international humanitarian law, and especially the Geneva Conventions, they are a reaction of the times, the conflicts, the typology of conflicts that reflected those times, which is mostly the international armed conflict between two or more states. And of course, there is an exception to this that we find in the Common Article 3 to Geneva Convention that addresses the issue of non-international armed conflict. Today, and in the past decades, we have seen the transformation of armed conflict, which are now mostly defined legally as non-international armed conflict. But outside of this legal terminology, they can be called hybrid or proxy wars, and they very often involve external actors, be that state, be that economic actors, be that private military and security companies or mercenaries and other related actors. So the modern armed conflicts have been transformed, and the international rules have not been following with the same speed the transformation of the conflict. However, the economic actors are still very present. And those civil wars, as we can call them, have a specificity, as I said, to be fed with the exploitation of natural resources. The character of the natural resources plays an extremely important role in the type of conflict that we can see. And so there is an obvious link between the different types of natural resources and non-international armed conflict in particular. Why? Some natural resources that are very easily to extract, such as diamond or gold or other small natural resources, will be, and they don't require sophisticated technology or the specific knowledge to extract those, would be usually benefiting non-state armed groups that are present in non-international armed conflict. And the pattern that we can see very often is that the non-state armed groups would extract those natural resources and then change it with arms, and in order to sustain and to reinforce their military capacities. On the other hand, we see the natural resources such as oil and petrol that require long-term investment, sophisticated and very complex technology, and of course the knowledge, engineering, and other expertise. And those type of natural resources often benefit states or sophisticated actors, and I can come back to that later, but mostly states through the state contract, so the legal contractual relationship between economic actors, the business entities, and the state. And so we can see these type of patterns between the character of natural resources and how they can actually sustain the wars, and in particular the contemporary non-civil armed, non-international armed conflicts. That brings me to the next point in this particular aspect, and that's the legal versus illegal. Very often we say, well, and that's very often the cases of fact-finding missions and investigative bodies. They have the mandate to investigate illegal pillage, and the states say, well, this is the illegal exploitation of natural resources. They usually benefit to the non-state armed actors. But almost never, or extremely rarely, the legal exploitation of natural resources is ever addressed. And this is a problematic aspect that requires more attention. I'll give a concrete example on that. The working group on the use of mercenaries has presented a thematic report on the extractive industry relationship with the private military and security companies. That report, the code is 42/42 of the Human Rights Council, was presented to the Human Rights Council in September 2019. And one reason why this was interesting was to explain, to demonstrate how the traditional concepts of international public law, such as subjects of international law, sovereignty, legal versus illegal, do not correspond to contemporary situations today. And in this report, we have actually addressed the legal and only contractual relationship between extractive industry, different type of private security companies, local and international, with the state authorities and state police being involved in this type of contractual relationship. And very often, these are linked also to the land grabbing, mass expulsion of people from their land, the rights of indigenous people, right of people to self-determination. And of course, these are all human rights abuses that we see, the torture, disappearances of human rights or environmental defenders. And they take place through legal contractual relationship because the state, as a sovereign state, has the capacity to pass those international contracts. So the legal versus illegal comes very important in terms of the business and human rights in armed conflict doctrine. And of course, one point before I dive more into the details of the business and human rights in armed conflict, the last point I'd like to address in my introductory remark is the asymmetric role of corporations in international law that we see. On one side, there is a position that corporations are not subjects of international law, and therefore they cannot be held liable or responsible under international law. On the other side, corporations can claim the protection of their human rights, even though they are not human, and this has been recognized. And there is a very continuous jurisprudence, the case law of the European Court of Human Rights, and in a way through the Inter-American Court of Human Rights as well. Although it doesn't have direct jurisdiction over corporate entities, it does have over individuals that are corporate directors. And so we see this asymmetrical approach to corporations in international law, where they can also contribute to drafting the rules of international law. We say, well, only states can sign and ratify international convention. But before we even come to that, there are so many other ways where corporations can influence international law. For example, by lobbying with specific states, or by contributing as experts in discussions on specific international convention or international law negotiations. They can also contribute to the development of national or international law by adopting soft law initiatives that can be then transformed into internal regulation, or the soft law initiatives that will be multi-stakeholder initiative where corporations have their input and will be transformed into domestic legal system as legislation. So we can see that they are very active and they contribute to international law formation in one way or another. They have their protection as human rights protection, not to mention also that they have the right and possibility to initiate international proceedings before international economic institutions against states, but vice versa is not possible. States cannot introduce proceedings before against corporations in the same proceedings, same institutions. And so there is a total asymmetric approach to the role of corporations in international law. Now, what are the corporate obligations under international law? So, because the traditional doctrine on international public law says, well, only states are the subjects of this law, and to a certain extent, international organizations, and still under discussion, but it's recognized that individuals are either subjects or objects, according to the different doctrines of international law, because they can be prosecuted before international courts. But corporations are not recognized as subject of international law. One argument being the fact that states do not want them to draft international rules, and which is very contradictory to what I just explained about their contribution to international rules. So, because the corporations are not considered to be subject of international law, the way the states have approached to corporate responsibility issue was through what is called the soft law initiatives and multi-stakeholder initiatives, and the notion of corporate social responsibility. There are several issues around soft law initiatives, and in particularly the notion of corporate social responsibility. First, the corporate social responsibility is the notion that has been very much accepted by corporate actors themselves when the whole discussions on corporate liability started a few decades ago in the United Nations system. And it is an approach where the corporation said, well, actually, we do not want any legally binding rules for us, but let's take the different approach, the soft law approach, where we're gonna be socially responsible whenever this suits us. We can choose between the initiatives. That's one problem of the corporate social responsibility. The other problem is that the corporate social responsibility is very much developed around the notion of due diligence. And due diligence is another notion that itself is very flu. It's very complex. It actually comes from the financial world and in the international sphere on state due diligence. But the violation of due diligence, even when the corporations adopt this notion as the due diligence and they make engagement to comply with due diligence, the violation of due diligence does not constitute a legal basis to prosecute corporations for, let's say, grave human rights abuses or international crimes. So this is a very weak legal aspect of a corporate social responsibility proceedings. Another aspect that is related to the soft law initiatives is that it's very much fragmented in terms of which type of corporations that will address or the fields of expertise of the corporations. So we can see a sectorial approach, whether it reflects only to private military and security companies or initiatives that relate to private financial sector and private banks, or the initiatives that reflect to the extractive industry only. And so they are fragmented. They do not address all the corporations in one specific document, and I'll come to the guiding principles in a second. And then, of course, this has been remediated in a way through this UN process that was initiated a few decades ago, that was culminated about 10 years ago, or actually 10 years ago specifically, as we celebrate GP plus 10 this year, the UN Guiding Principles on Business and Human Rights. That is a kind of a compromise between what corporations were pushing for and what states accepted, between the North and the South, and between the civil society and states and corporations. And these UN Guiding Principles are formed in three parts. First, they remind of the state responsibility. The second, the corporate responsibility to respect human rights. And then the access to remedy in its third part. Now, the UN Guiding Principles were what we can say a necessary step towards legally binding instrument. It takes time to transform minds to transform minds of the state, to transform mind of the corporation, and also the civil society. And it takes time for the process to be kind of unified, or to absorb different approaches, different legal cultures, different socio-economical aspects of various states. So going through the UN guiding principle was a positive step in that sense, because it was the first step that reflected those. However, the UN guiding principles, and we are now 10 years later, so we can make some kind of evaluation on the success, turns out to be something that is very often a window dressing, where corporations say, yes, we will, we accept the UN guiding principles, we will comply with the guiding principles, but this is often something that's very nice on the website, that's part of their social or environmental sustainability internal policies. But what we can see on the ground in the field of operations, and especially in the conflict zone, this is very much absent. And that leads me to the final part of the corporate social responsibility approach altogether, is that very often, in most of those initiatives, including the UN guiding principles, it is extremely, extremely weak on the business and human rights in armed conflict. And it does not reflect armed conflicts more often than it does. And when it does, it reflects it in a very limited way, and quite often in very unrealistic approach, being quite dissociated from the field of operations, and to see what exactly does it mean for corporate actors to operate in a zone such as South Sudan, Sudan, DRC, Democratic Republic of Congo, Libya today, Syria, Central African Republic, and others, Myanmar, for example. So those social soft law initiatives, corporate social responsibility, are very limited in their approach, and yet they are very much founded on this traditional approach to international law, where corporations are not considered to be subjects of international law. Now, business and human rights in armed conflict has one big advantage, that international humanitarian law applies in the context of armed conflict. And international humanitarian law is a very realistic body of law that has a very pragmatic approach to addressing situations and actors participating in armed conflict. And one thing that's very that comes very handy coming from the international humanitarian law when we want to address the doctrine of business and human rights in armed conflict is the issue of the non-state actors being bound by international humanitarian law. And there, again, the common Article 3 to Geneva Convention addresses originally non-state armed groups. But as we can see, the evolution of armed conflict and the evolution of the doctrine, we see that very often doctrine is very consistent in applying international, in positioning themselves that international humanitarian law should and does apply to other non-state actors that are active in armed conflict. And my position here in particular is that international humanitarian law does apply to corporate actors operating in armed conflict. And international humanitarian law does not require for them to be considered subjects of international law, because it addresses other actors that are not subjects of international law. For example, non-state armed groups that are directly addressed by the common Article 3. And so we do not, when we discuss international humanitarian law and corporate actors, we do not need, in my opinion, to define corporations as subjects of international law in order to apply international humanitarian law obligations on them. And that has been a very obvious case for some type of companies, for example, private military and security companies that contribute directly, they participate directly in hostilities, would be bound by international humanitarian law. Civilians are bound by international humanitarian law, so civilian actors, civilian employees of corporate actors such as extractive industry that are present in the context of armed conflict but are not necessarily participating directly in hostilities would be bound by international humanitarian law. Now, the debate is still very much active as to whether human rights law would apply to corporate actors. And maybe you have seen that recently in March this year, in March 2021, several mandate holders of the special procedures have taken for the first time the common institutional position that human rights law should apply to some non-state actors and that corporations have the responsibility to comply with human rights law. And this has been a growing trend, although it has to be very clear that it's a very different approach than to international humanitarian law, because human rights law, just like international public law, is more state-centered, and it's very much based on the traditional doctrine of international public law, where states are subjects of international law, and therefore primarily responsible to respect and ensure respect of human rights law. But we see the growing trend where human rights law can be said to be applicable to the corporate actors. Which means that if we take this position that at least international humanitarian law applies to corporations, and in some contexts, and to some extent, human rights law, that means that corporate actors can commit international crimes. Now, we have another body of law that comes very handy in this context again, and that is what some can call the extension of international humanitarian law, is the international criminal law. And international criminal law, since its birth, international criminal law has been very useful in terms of corporate liability. So from the Nuremberg trials, we have the cases that have been very useful. For example, the affaire Schacht before the International Military Tribunal of Nuremberg that addressed the issue of the military provision and armament of the Nazis. However, it dismissed the case because the armament was not considered to be crime under the Charter of the International Military Tribunal, but nevertheless addressed the issue and recognized the importance of role of economic actors in the provision of military services and products to the actors and parties to the conflict. Similarly, the Tokyo Tribunal addressed the link between the economy and crimes in the Naoki and Kayao Nori case. We have also other tribunals that addressed the economic crimes, the economic actors and their contribution to international crimes in the Nuremberg proceedings. One being Zyklon B case before British military court in 1946, where the court addressed the contribution to the perpetration of the crime by the Zyklon B company. The other one is the Röchling company before the Tribunal Militaire Français, French military tribunal in 1948, that addressed the contribution to the continuity of the war of aggression, and it actually condemned directors. And of course, we have three famous cases from the Tribunal Nuremberg proceedings. The case of the Flick in the 1947, where the tribunal considered the criteria of the should have known in the financial contribution of criminal activities. That means that the company, through their corporate directors, should have known that they contribute to international crimes by their financial contributions. The IG Farben case from the 1948 where the tribunal recognized that the legal person can violate international humanitarian law. And that brings me to the applicability of international humanitarian law to the corporate actors. So as early as 1948, the tribunal recognized that a corporation can violate international humanitarian law. And the same tribunal recognized that the accused used the corporation as the instrumental in the commission of crimes against the peace, war crimes, and crimes against humanity. In the case of Krupp in 1949, the criminal liability of legal persons related to the individual responsibility of company directors. And in the Krupp case, the court explicitly acknowledged that Krupp company violated the Article 43 and 46 of the 1907 Hague Regulation. The court recognized that it does not have jurisdiction over the company, but it did recognize that the company itself violated the Hague Regulation of international humanitarian law. In recent contemporary criminal court proceedings, the ICTR, the International Criminal Court for the Rwanda, addressed in the case of Musema the issue of tea factory and the position of power of the corporate director of the tea factory in inciting to the commission of the genocide. And in the case of Nahimana, which is the famous media case, where the media as a legal entity contributed to the incitement and contribution to the genocide. The Special Tribunal for Sierra Leone also addressed the role of economy in armed conflict. Now, I'm very careful here because it did not address the corporate responsibility as such, but it did address this pattern, as I started with, between the extractive industry, extraction of diamonds and gold and some smaller natural resources, and the pattern of circulating, sending them for the arms and, of course, arms transfer issue and the sustainability of the military capacity of armed groups. So the role of economy was addressed by the court. And finally, one of the most important recent cases was the Special Tribunal for Lebanon that explicitly recognized that the corporation as legal person can be responsible for human rights violations and for international crimes. So the international criminal law, from its inception until today, the modern tribunals and modern case law has been addressing this issue and has been continuously considering the role of economic actors and the economy, and it's linked to international crimes, but also to the armed conflict. And at any point, that none of those tribunals dismissed the idea, in any case, not explicitly, that corporations should not be held responsible for international crimes. And I think this is a very important development that we see in the field of international criminal law, and it's a very useful tool when we advocate for corporate responsibility in international sphere. Today, how can we approach the issue of business and human rights in armed conflict? There are some criteria, and I think one challenge or one concern that we should, one risk perhaps, that we should avoid is to fall into the same trap as the soft law initiatives did, to say, well, we can address extractive industry one way, we can address PMCs, private military security companies, in another way, and approach it by different sectors or by different categories of corporation, big corporates, multinational corporation, and small national corporation entities, small and medium. This should be avoided. What should be used as a criteria in establishing corporate responsibility is the corporate link to the armed conflict, which eventually could bring to the war crimes type of crimes, and the link with the crime itself. And this is something that is irrelevant of the sector in which they operate, and it's irrelevant to the size of the company. And it's these two criteria are objective criteria to address corporate responsibility, and they form unified, harmonized approach to the corporate responsibility. Just like like we have in international public law in the case of state responsibility for wrongful acts, the state draft articles on state responsibility do not address small states or big states or democratic states or dictatorial states in different ways. They address states, and the state responsibility is examined through objective criteria which are examined in each context and to each state. This way, we also adopt neutral, independent criteria that will be addressing the corporate responsibility regardless of their sector of their operation, the size of their operation, and the place of their operation. So the link with the armed conflict and the link with the crime would be the first relevant links to consider. The second thing that we have to consider in terms of way forward and how to address the corporate responsibility in terms of armed conflict is different types of relationship. So, as I said, the contemporary armed conflicts today are very complex in comparison to the classic interstate armed conflict. And we see now multitude of different non-state actors operating in non-international armed conflict around the world today. And there is a multiplication of those non-state actors, from non-state armed groups, what some may say terrorist fighters, foreign fighters, mercenaries, and different typology that we may call them today. The corporate responsibility in terms of business and human rights and armed conflict should be very mindful of those new actors and new type of relationship that comes with those actors, who also have a need to sustain their military capacity if they want to continue to participate in those armed conflicts. Therefore, the traditional approach of international public law, where the state is in the center of any type of responsibility, is not adapted to this context. And we have to consider the relationship between corporations recruited by state, or corporations recruited by extractive industry, or corporations operating in relationship with non-state armed actors. One thing that we found was part of the findings of our extractive report is that private military and security companies today have their major client extractive industry. So that is a very complex new relationship between extractive industries, which are very often multinational companies operating in the conflict zone, and recruiting sometimes national private security, but also sometimes international, multinational private military and security companies. And these two types of corporate entities working together is a very specific relationship, again, legal at the appearance, but not necessarily fitting within the classical paradigm of international public law. One thing that has to be also considered is the attribution of the acts to the corporations, and that contemporary doctrine on corporate responsibility, and that includes the soft law initiatives, including the guiding principles, very often depart from the fact that corporations are complicit to international crimes. And it's a prejudice, and it actually is opposite of how the international proceedings should be conducted. First, we examine the fact, and then we can see, based on the facts, whether in each case corporation has been complicit or has been actually directly participating or co-author of the crime. And once we actually examine some of the cases in detail, in weak governance countries, we can see that corporate entities, especially the multinational strong corporations, have been so strong in lobbying that the national authority do not actually have so much to say, and also the state needs the foreign investment, that the multinational companies have been actually inciting the state to forcibly displace population, to clean the land that could be potentially used for extraction. And so the corporate actors could be actually inciting the commission of crimes, or being co-author of, or giving the order and directly participating in the crime. So not just being the complicit in the crime. Where do we stand today in terms of different mechanism, in terms of being having some kind of jurisdiction of the mandate to address corporate responsibility for, especially for the crimes in armed conflict? Well, basically, I would say nowhere, but that's not quite true. It's a false presumption that there are no international proceedings on corporate responsibility. There are two. One of them is being what is called the special procedures of the Office of the High Commissioner for Human Rights, under the umbrella of the Human Rights Council, where special rapporteur, working groups, and independent experts can address what is called communications under the communication system, allegation letters to the states on the alleged human rights abuses, but also to corporate entities and other non-state actors, in this case, corporate entities that we are interested in. And so, for example, Working Group on the Use of Mercenaries has addressed in the past allegation letters to private military and security companies, but in our most recent actions in March 2021 in the context of the Central African Republic, we also addressed the allegation letter to the company that's called Lobby Invest, that is an extractive company operating in and registered in Central African Republic. So based on these allegation letters, those communications are sealed for 60 days, but then they become public, and they can be a very useful tool for lawyers when they initiate domestic proceedings, or civil society when they want to initiate or when they do advocacy with state authorities on specific case. For example, in the past, we have addressed the situation of corporate actors land grabbing and indigenous people, or access to land, attacks on human rights defenders, environmental defenders, and those communications are now publicly available and are the only international proceedings that address corporate responsibility. The other proceedings that are of what we can call international character is the popular tribunals, one of them being the Russell Tribunal, where those tribunals are initiated by the civil society, and they could have character, they land some characteristics of international criminal proceedings, although they are not international criminal proceedings as such. But they have, for example, the jury, presentation of evidence, the condemnation kind of aspect. And so they try to look, to have the appearance of the international tribunal, but they are not international tribunal that are state organized or state supported. Rather, they are, as I said, initiated by the civil society. And one of the aspects of popular tribunals, and in particular Russell Tribunal, is to address the situations that have not been under the radar of the international community, but are of a great concern, and to address the actors that are not addressed in traditional institutional proceedings. And so popular tribunals very often address corporate actors, and there have been cases of extractive industry all over Latin America, the Special Tribunal for Mother Nature, and others. And there is a whole case law on that. But again, these are the civil society initiatives. There are now 2 or maybe 3 proceedings, and this is where I'm going to end my presentation, that are of relevance for the future discussion on corporate responsibility. One being the Intergovernmental Working Group on Business and Human Rights, that I'm sure you're all very aware because it's a very popular initiative that is currently discussing the content of the draft treaty on business and human rights. And it holds its sessions once a year, usually around November. The last one was the last November 2020. And it currently experiences some crisis, I believe, because the general multilateralism is in crisis, but there have been some, what I would say, a split in doctrine between taking UN guiding principles to a next level, to a legally binding instrument, which could potentially bring also the discussion on international criminal liability of corporate actors, and whether we should pursue the classical doctrine of corporate social responsibility, due diligence, and under the UN guiding principle umbrella. So this is one forum where the discussions are taking place right now. The other forum is another intergovernmental working group, and here we see again the aspect of fragmentation. The Intergovernmental Working Group on Private Military and Security Companies that, of course, address, as its name says, only the potentially future instrument independent of the nature. The Intergovernmental Working Group has a specific mandate not to say what will be the nature of the future instrument. So it might be the international convention, it might be the model legislation, it might be something else. But it's addressing the possibility of holding legally liable private military and security companies, which is only one particular type of companies. So it's a sectorial approach to corporate responsibility again. And it's a risk, but it's a risk of fragmentation. But it has actually moved forward pretty well this year in April 2021 under the chairmanship of South Africa. And discussions were very fruitful and motivating. And of course, the last forum, and I'll end with this, is the potential amendment to International Criminal Court to introduce corporate legal entities. And here is a debate whether we should discuss the legal entities. And if we insert legal entities, what does it mean in terms of legal entities? Does it mean also states or other actors, or just corporate actors? These are the minor details. But the other aspect that is a bit risky in terms of negotiating the potential amendment to the Rome Statute is the issue of environmental crimes, or what you probably have been following in the last few weeks, the definition of the ecocide, and whether the discussions on the amendment of the Rome Statute should focus only on the introduction of the new crime of ecocide, or the corporate responsibility, or both. And here, I like to take a very firm position to say that only the comprehensive approach to corporate responsibility should be favored, which means the corporate responsibility should be included, as corporate legal entities should be included in the Rome Statute, but also with the responsibility to the environmental crimes. And I think more we ask for, more we have chances to get. Less we ask, obviously, this is a mathematical schema, less we're gonna get. And I would not dissociate too. And I'll thank you for your attention, and I'm open to the questions. I'll end my presentation here. Thank you.
And we thank you very much, Jelena. And first of all, we have some questions, and I'd like to ask you if you prefer me to do one question by time or like 3 questions at once, and then another 3 questions. I'm sorry, you're muted.
Sorry, we have that many questions. All right.
Not so many. I mean 10 questions.
Oh my God, I'll stay until midnight. All right, let's have 3 questions per 3 questions, and then I'll see.
So the first 3 questions, and it's going to appear for you here in the screen. About sourcing natural resources in NIAC, do you think the current human rights due diligence legislations are sufficiently covering these situations? If not, what other provisions should be there? And second, as non-binding rules, do you consider it possible to soft law regulate and criminalize illegal acts of companies in non-international armed conflicts? And the third and last one, how can we hold these enterprises responsible for financially supporting non-state actors in armed conflicts by extracting natural resources?
Okay, can you just please repeat the second one and more slowly if possible?
Second, as non-binding rules, do you consider it possible to soft law regulate and criminalize illegal acts of companies in NIACs, international armed conflicts?
Mm-hmm. Okay. Okay, well, so the problem of the extractive industry in non-international conflict is something that is really of almost a normal case scenario today, and it has been almost systematically happening in different places. And I said different actors feed from different sources and contribute to the sustainability of armed conflict. And this is why we often see that non-international armed conflict, when they are linked to natural resources, often takes 20, 30 years that they last. As I said in my presentation, the soft law initiative very rarely address the issue of armed conflict in general. Now, there are some initiatives, for example, the Kimberley process that address only the sector of diamonds, does not address the sector of gold, and there is nothing on the gold sector, to be honest with you, actually. And we've seen the limitation of Kimberley process as we see it, for example, in some contexts today, where they actually authorize circulation of diamonds in the places where there is an intense combat, an intense conduct of hostilities taking place. So I'd say there is a little bit of a failure on that thing of the Kimberley process. We see also the voluntary initiative on the extractive industry and private security providers that addresses those issues. But again, they have very narrow definition of what is the extractive industry. And then there we have sectors such as soft law initiatives such as Montreux Document or International Code of Conduct that address private security providers that could potentially be linked to the extractive industry. So again, there is different sectorial approaches from the soft law initiatives that give the appearance that something has been done, that there is some kind of a legal framework addressing these contexts and potential issues in human rights abuses. But it's really, some people call it window dressing from the companies that accept those voluntary initiatives. But it's really it's to create confusion. It's to create the illusion that something is taking place. In reality, and in terms of concrete application, nothing is actually useful out of those soft law initiatives. First, because in the field of operation in the conflict zone, it's really hard to comply with them, or it's very easy, to put it differently, it's very easy to ignore those soft law initiatives. And it's very easy to ignore them because very often those soft law initiatives have a very big technical problem, is that they don't have oversight mechanism. So the mechanism that would control the compliance of the company that is a signatory to this soft law initiative. And another aspect to the issue of oversight and compliance with the soft law initiatives, which will be also the case for the legally binding norms, is going to the conflict zone and actually investigating. And it's actually one of the problems of the fact-finding missions today and investigative bodies, is that at the time when corporate actors contribute to international crimes, be that extractive industry in, I don't know, in south of Libya, Central African Republic, Congo, you see the places that I'm naming, you can understand immediately what is the security context and how hard it is to any investigative expert to even go to that place, then less to investigate crimes. And very often when the security allows any type of investigation, even if it would be the case for soft law initiatives, it's already very late, and there is a problem of different jurisdiction, of mutual legal assistance between domestic prosecutors, if there would be domestic proceedings, sharing the evidence, collecting the evidence. How can, for example, a French prosecutor obtain the evidence of the Lafarge company that has been financing non-state armed groups in Syria in order to continue to operate? If the state where the host state where the crimes take place is not necessarily cooperative. I mean, those are all issues that are very pragmatical and technical issues that we need to be very realistic about when we address them. And so one of the things that is part of the discussions on the international forum, and also in terms of the financing, is how can we collect the evidence? How can states between themselves proceed in exchange of information and evidence and cooperate between them? And I think this multinational aspect of the case that raises different jurisdictional obstacles and challenges is very important, and it is one part of the discussion. So the soft law is of no use for armed conflicts, for sure, in most cases. And as I said, international humanitarian law is useful and could be the basis for international crimes, if nothing else, at least of the corporate directors that are involved. But unfortunately, we haven't seen any prosecution against corporate directors, and this has not been part of the prosecutorial strategies of previous prosecutors of International Criminal Court. And to some extent, it has been addressed before the International Tribunal for the Rwanda. But again, one thing that is very concerning, and it's something that is common to international criminal proceedings as it is to investigative bodies and fact-finding missions, is that the approach to investigation, to documenting violence and crimes and human rights abuses, is that it addresses only the local actors, at the very best, regional actors, but very rarely international actors and role of international economic actors in war crimes. And that's a whole different aspect to it.
Okay, so I will now proceed for our next block of questions. So our fourth question is there a type of international crime under the Rome Statute under which it's easier to frame the criminal responsibility of corporations? For example, does the organizational policy requirement for the contextual element of the crime against humanity make it easier to hold corporations accountable under international criminal law? Our fifth question is is there a relationship between superior responsibility under Article 28 of the Rome Statute and criminal accountability of corporations? And our sixth question, what are the differences regarding the responsibility of states and the head of state for the acts of their soldiers and for the acts of employees of PMCs acting under the same state?
This last question, that would be the difference between state, the heads of state, and could you please repeat that just to be sure that I understood?
Sure. What are the differences regarding the responsibility of states and the head of state for the acts of their soldiers and for the acts of employees of PMCs acting under that same state?
The PMCs. Okay. As it stands today in terms of the ICC, as it stands today, corporations can commit or contribute to the international crimes under the Rome Statute. And there have been some that have been raised before domestic courts or in communications that were sent to the International Criminal Court. Those would fall in some instances under war crimes. Some they would very easily fall within the crime of humanity, or rarely, but there have been some examples linked to the genocide, where they would contribute to the genocide. So the corporate actors could contribute, and I'm going to come to the forms of contribution, could contribute to the crimes that are currently in the Rome Statute. In terms of the forms of contribution, as I said, it depends on the context, but let's say private military and security companies would very likely fall under the scenario where they commit war crimes, very likely, especially because they operate very often in armed conflicts, and very often they are associated to the crimes that take place in those contexts. They could contribute to the crimes against humanity as well, directly, although here we are also entering the complicity doctrine, more likely to be the case, and the genocide also. If they would contribute to the genocide, it would most likely be under the complicity doctrine rather than direct perpetrators. But again, these are just the examples and illustrations because they are more likely to take the place. But it should be established on a case-by-case basis and on the presentation of evidence and facts in each case. What I have found in my research, I have found the scenarios where private military security companies did commit war crimes under my research, but I'm not an international tribunal, so very limited evidence, of course. I found the cases of extractive industry. In fact, I use these three types of companies to illustrate some of the examples. So the private banks, extractive industry, and private military and security companies, where private military and security companies would be very likely fall within the direct contribution to the crime as a direct perpetrator. Extractive industry could fall within the co-author of the crime when they incite the governments to, for example, move the population, and when that government has the policy to move one specific or three specific ethnic groups that could potentially fall within the policy of genocide. And we've seen those cases in Darfur, and the extractive industry would simply contribute from that policy and have concession contracts. Or we have the private banks that would definitely form under the complicity, simply because they are not in the context of the armed conflict, but they are somewhere in Western world or other states far from the armed conflict, but they are financing and they are not, and they are actually quite aware of what they are financing, but they continue to finance that. And we have seen the cases of BNP Paribas before American domestic courts that addressed the issue of, for example, Sudan, sorry. And if that court in America would have had jurisdiction over the crimes against humanity or perhaps even genocide, could potentially examine the case under those crimes. But it was a different type of tribunal, nevertheless. So there are possibilities to link them to the crimes that are currently existing in the Rome Statute. There are possibilities to hold corporate directors as crimes, and this is something that the Chiquita communication has also revealed, to say, the Chiquita company, it was the Harvard Human Rights Legal Clinic and other actors that presented that presented the communication to the ICC, and they said the communication is based on the domestic proceedings against corporate entity, but you, International Criminal Court, have the jurisdiction over natural persons only, so you can address director responsibility for the crimes that took place in Colombia. And some evidence has already been found for you, and they presented the case. And under the seal, it was 15 or 16 corporate directors that was presented together with the communication. The communication is public. So the corporate directors could be held criminally liable under the current provision of the Rome Statute. It's the corporate entity that would need to be introduced into the. And one thing that I think in terms of the command responsibility that is extremely useful when we talk about parent company and the subsidiary, and I have developed, some scholars worked on the command responsibility, and I have developed the command responsibility within the business and human rights and armed conflict doctrine based on the initial doctrinal analysis. And it is very possible that we apply command responsibility in this relationship between subsidiary and the parent company, which is a complex relationship and very often can have multiple parent companies, one subsidiary. So I found command responsibility useful, and but again, for command responsibility to be applicable to corporate entities themselves should be integrated into the Rome Statute. So the command responsibility as it is right now in the Rome Statute can only address corporate directors and their command responsibility over their employees, which can be very useful in the context of private military and security companies, but not only. For example, it can be useful command responsibility of corporate director of extractive industry that gives orders to his internal staff, who is head of the security and who will actually give orders again to his staff, who are national or international recruited security providers or in-house security providers, the in-house being employees of that company. So there is a very clear chain of command, and who would then be committing human rights abuses against, for example, human rights defenders or environmental defenders. So command responsibility certainly is a very, very helpful doctrine in establishing on a different levels and in different contexts corporate responsibility, or at least corporate director responsibility. State responsibility and the heads of state and private military and security companies. Well, state responsibility is a specific proceeding under international public law today, as you know, and the state responsibility is mostly conducted through the jurisdiction of the International Court of Justice, or it can be conducted for different topics before other international economic tribunals or arbitrations. the heads of the state, and we have seen the cases, for example, with the Yugoslav war, where the International Court of Justice addressed crimes of genocide, the same genocide that took place in the former Yugoslavia, and the International Criminal Court, namely the International Tribunal for Yugoslavia, former Yugoslavia, addressed some, they didn't have the time to address head of the states, but they addressed higher civil and military commanders for the same genocide, so the same criminal act. So two different international tribunals can address the same act but different actors. And we've seen, specifically with the control theory, how the courts can take different doctrinal approach, where the Tadic in Nicaragua was contradicting in terms of the theory of control, whether it's the control of the control theory. Sorry, I'm tired now. If there is enough link of the role of the private military and security company to the specific state, that state could be held responsible under the draft articles of the state responsibility before International Court of Justice for the acts of private military and security companies. We have not seen that today. And to be very honest, anything that relates to the private military and security companies in terms of their employees or the companies themselves has been so obscure in terms of contractual relationships and acts that can take place in the conflict zone. And even when there is some information, there is still confusion about different relationship and structures of command and who's giving orders, enough not to give enough evidence for the beyond reasonable doubt that is very often required in criminal proceedings. So unfortunately, I'm very sad to say that we only had one case where we had, out of international or in our domestic proceedings, where we had criminal condemnation of PMCs. And that's for the famous case that you all know, the Blackwater, for former employees of the Blackwater that committed the massacre in Nasuri Square in Iraq in 2003. They were condemned before American courts, and unfortunately, and this is the only case where we actually reached the condemnation, so the proceedings took place from the beginning till the end with the final legal result, the condemnation itself. And unfortunately, former president of the US, Mr. Donald Trump, pardoned those employees. And now we don't have any more cases in terms of the PMCs. But under the classical state responsibility doctrine, PMC actions can be attributable to the state if we have enough access to information.
So thank you very much, Jelena. And I'm going to make the last question. So if we consider that private military and security companies are parties to an armed conflict, do they have the same obligations under IHL, similarly to any other non-state armed group? Or do we have to apply IHL obligations on them under a sliding scale approach?
I feel like this is more in my capacity as a chair of the working group on the use of mercenaries. I'll say what the working group on the use of mercenaries, the position is that we examine on the case-by-case basis, and based on the information and the evidence that we can access, which is not always very easy. And we have been continuously calling for states for more transparency and legislation that will authorize access to information, especially to the civil society and to the lawyers, to understand what are the contractual relationships, what are the contents of contractual contracts signed between the state and private military security companies. We believe that lack of access to this information is one of the main reasons behind the accountability, or more lack of accountability in this case. To answer the question, yes, the private military security companies, whenever they operate in armed conflict, are bound by international humanitarian law. And if they violate this international humanitarian law, employees of those companies should be held accountable under the different jurisdiction and relevant regimes. It's very simple.
So that's the questions. I'm sorry if anyone who's watching still have questions. You can send by email for Jelena if you don't have any problems with that. And so to finish today's webinar, we want to thank our guest speaker, Jelena, for sharing her precious time and knowledge with us. I imagine it must be a little late there in Paris. So it was an honor and a pleasure to learn from you. We also want to thank all the attendants for your interest and presence today. And I'd like to inform to anyone that the live stream will be available in your channel. So if you'd like to be notified, do subscribe. And lastly, we invite you all to follow the clinic's work through our social media accounts, which are in the video subdescription below at IHL Clinic, and to be tuned for our next events to come. So thank you very much.
Thank you. Thank you for inviting me.